Hello, everybody, and welcome back. This is Rachel with Justice for South Dakota, and today we're going to review how do you establish jurisdiction over people? What truly grants courts the legal right to confiscate life, liberty, and personal property? So, what exactly is jurisdiction? And that's what we will be looking at. It's vital to determine before a lawsuit is even filed which court has jurisdiction. Judicial jurisdiction is the difference between state lawsuits and federal lawsuits. And then it's further broken down to geographical areas. So if you're in federal court, different courts have jurisdiction over a certain region, and then they answer to courts which have jurisdiction over multiple states, all the way up to the Supreme Court of the United States, which has jurisdiction over the entire United States and territories. State courts have jurisdiction over matters within that state. Different levels of courts have jurisdiction over lawsuits involving different amounts of money. Like a bankruptcy court, it depends how much money is involved as far as which judge you get, because if it's over a certain amount, then it has to go to a higher level judge. In order for a judge to proceed in a case, they have to state on the record how they have established jurisdiction according to the law over two things. First, both parties to the lawsuit and the subject matter of the lawsuit. Now, both of these jurisdictions are established by legislative statutes and signed into law by the governor. Personal jurisdiction refers to the power that a court has to make a decision regarding the party being sued. The U.S. Constitution requires that the party has certain minimum contacts within the forum in which the court sits. Typically, in order to file a lawsuit and have personal jurisdiction, it has to be filed in the county where the defendant resides, unless there is certain legislative stipulations that do otherwise. So it is possible to sue a non-resident in a state where they do not reside, as long as they meet these stipulations. And then as far as subject matter goes, the legislature has to specifically state under what grounds a judge is allowed to preside over a case. And if these jurisdictions are not met, then the judge would be proceeding in the complete absence of jurisdiction. So what happens if you do proceed in the absence of jurisdiction? Well, it is extensively established through case law, case after case after case, in addition to legislative law, that every single proceeding and order entered into the suit is nullified and void if the judge intentionally presides over a case with which he has no jurisdiction. The judge himself is subject to personal liability in a civil suit, and it's also grounds for impeachment, which is removal from office and no longer allowed to hold another public position. Personal jurisdiction is established if it's the right state. We already said in an earlier episode that a Florida citizen cannot be subject to the laws of South Dakota, And likewise, a Washington resident cannot be subject to the laws of South Dakota because the United States Amendment said that you have to be subject to the state wherein you reside. This law it completely limits both federal and civil court, and it's part of the due process clause, which the earlier lawsuit with the Native American Indian children, it was violated because only the Indian court could uphold their or issue decisions in their cases, and the Pennington County judge was doing it instead. So here's the United States Constitution, 14th Amendment, which states that all citizens are subject to the jurisdiction of the state wherein they reside. What happens if you're a non-resident? Well, South Dakota has dealt with this topic as well, and it says that you can exercise jurisdiction over a non-resident as long as, first, the legislature has granted the court jurisdiction pursuant to South Dakota's long-arm statute, which is 1572, and the court must then determine that the exercising the jurisdiction over a non-resident complies with federal due process requirements. And this was released by the South Dakota Supreme Court in 2014 in the Custom Cycles versus Bauer lawsuit. There's extensive case law throughout the United States which deals with this issue, and it says that subject matter jurisdiction is the court's statutory or constitutional power to adjudicate the case. That was Steel Company versus Citizens for a Better Environment, and that was decided by a federal court. Because subject matter jurisdiction involves a court's power to hear a case, it can never be forfeited or waived. And that was United States versus Cotton, which is also another federal case in 2002. And these are gold standards for establishing jurisdiction or the lack thereof. Now, earlier we said that Kristi Noem is fully aware that her judges are disobeying the law, which she is, and any judge which intentionally disregards the statutory limitations of jurisdiction which the people of South Dakota have imposed on them are dictators. That's it. They are exercising outside their legally established boundaries. They are creating a group of law unto themselves, and they're a dictator because they don't care about the statutory limitations the people have enacted as a democracy and signed into law. They're creating their own. Justice for South Dakota is going to show you, through story after story, proven by facts, how the judges in Pennington County are dictators. They have no regard for the law, which was established by the democracy of people, and they have created a law completely unto themselves. These justices uphold rulings for white privileged males. It's not equal like it's supposed to be, like we talked about in episode 2 and episode 1. These justices intentionally destroy families. These justices obliterate female-owned businesses. If you stand up for your constitutional civil rights, these justices will stop at nothing to throw you in jail. Now, these stories do come at the price of either being killed, your life completely destroyed, and the person speaking out also being falsely accused and then convicted and serving prison sentences. This does not come lightly. Where does all this injustice happen? At 7th Circuit Court, Pennington County, South Dakota, the heart of corruption. Now we're going to look at Evans versus Evans, Court File 51, DIV 18-41, the absolute worst fake divorce in South Dakota history. The South Dakota legislature has clearly established guidelines for jurisdiction. On personal jurisdiction, it's found in Chapter 15-7 of South Dakota Codified Law, titled Jurisdiction of Persons. Subsection 2, 15-7-2, acts within the state, subjecting persons to the jurisdiction of the court. And if you are doing the following subsections, and with respect to any action for divorce or spousal support, court in the state of South Dakota has jurisdiction subject to the provisions of Statute 25-4-30. This is where subject matter jurisdiction comes in. If we go to South Dakota Codified Law, Chapter 25-4-30, residence requirements for divorce, the plaintiff in an action for divorce must, at the time the action is commenced, be a resident of the state or be stationed in the state as a member of the armed services. Now let's look at DIV 18-41. When did the commencement of action occur? And according to SDCL, which is South Dakota Codified Law, 15-2-30, an action is commenced in South Dakota when the summons is served on the defendant. So in this court file, DIV 18-41, Rachel was personally served on January 23, 2018. Timothy, meanwhile, had entered Rachel's house. He, when the sheriff knocked on the door, hid in Rachel's bedroom, while Rachel's 4 young children opened the door to see who was serving her at 8 o'clock at night. The sheriff sheepishly gave her the court documents, apologizing for coming to the house and having to do this in front of her children. He then left, and he tried to make this as pleasant as experience as possible. Timothy immediately exited Rachel's bedroom, came over to her, asked if she understood what the papers were. Rachel opened the envelope and started to look through them, and he said, "That's right, I'm filing for divorce." And then he promptly asked Rachel to go in the bedroom and have sex. Now, who is the presiding judge? Let's talk about Honorable Judge Connolly. On January 23rd, as a plaintiff and resident of Montana, Timothy petitioned for divorce in Pennington County, South Dakota. Now, Timothy admitted on the record that he had taken no steps to establish residency in South Dakota prior to petitioning for divorce. Timothy was being prosecuted in Montana as a criminal. He already had an extensive history of being found non-credible in multiple family courts, both in Hill County and also Lewis and Clark County. These court cases involved his first wife, Stacy Marie Goulet Evans, currently known as Clow, and subsequent child support proceedings. Now, Rachel filed an answer in response on February 6, 2018, and then she again emailed Judge Connolly. She timely objected to South Dakota's personal and subject matter jurisdiction, as the SDCL 25-4-30 clearly states Timothy was required to be a South Dakota resident at the time of filing. According to SDCL 12H3, a court must, that's actually SDCL 15-6, 12H3. The court must dismiss any case over which it lacks subject jurisdiction. So Rachel fully expected that this case would be dismissed because Judge Connolly had no subject matter jurisdiction. In the upcoming episodes, we're going to explore in detail how the divorce request that Timothy served upon Rachel was full of completely falsified quote-unquote facts. First, Timothy couldn't even name Rachel's 4 children by their names. He called them totally other names. He falsified other accusations on it, and then Timothy's attorney looks like a complete jackass because he's supposed to have verified every single fact prior to filing the papers. So he's trying to cover up his tracks. So he immediately tells Timothy to immediately establish residency in South Dakota. Now I have both of Timothy's driver's licenses up here. The one on the left is his driver's license from Montana. You can see that Havre, Montana was Timothy's home address. It was actually 910 14th Street is the physical address. And you can see that it was issued in 2014 and it expires in 2022. Now, the parts that I blanked out included Timothy's height. And the interesting thing is if you go over to the South Dakota driver's license, which was issued February 16th, 2018, Timothy couldn't even get his height correct. He claims he's 5'3" when he's clearly 5'8". His address, because Timothy had no physical address in South Dakota, so he just claimed Rachel's home address as his address, which I've highlighted there as well for you. Now, the interesting thing was he did it on February 16th. He filed for divorce and served it, also commencing the action on January 23. So what was Judge Connolly's response to all this? Judge Connolly clearly said, he could be a resident of Mars, it doesn't matter. Remember that every single thing that we're talking about is proven by facts. Please contact me and I will happily email you the complete transcript to this hearing, which proves, beyond a shadow of a doubt, Judge Connolly does not care about the established law of South Dakota implemented by the legislature. He is a dictator implementing his own law. He said it did not matter what the South Dakota legislature put into effect. He could be a resident of Mars. It does not matter. And then Judge Connolly proceeded to preside over the case in complete absence of statutory subject matter jurisdiction and in violation of South Dakota Codified Law 15-612, Section H and 3. So let's look at how the South Dakota Supreme Court has ruled on this problem in the past. In order to do so, we're going to look up Rush versus Rush, which was South Dakota Supreme Court case number 56 in 2015. They extensively reviewed contested jurisdiction, and the finding by Judge Connolly completely violated this case law. I've put down the full reference for you there on the left-hand side. And the Supreme Court ruled at that time that it was a mandatory 45-day residency requirement and physical steps to establish residency. Now, going back to the Rush versus Rush, it involved a Grant Rush, and he actually filed for divorce on July 30th, 2012. Grant did not own any real property in South Dakota. Remember, neither did Tim Evans. He used his wife Rachel's address. Grant did not have a South Dakota issued driver's license, nor was he registered to vote in South Dakota. Neither was Timothy Evans. There was no evidence that Grant had any long-term plans to move to South Dakota before he filed for divorce. Neither did Timothy Evans. However, what the court did find is that Grant filed for divorce and mailed a copy of the summons, 2 copies of the notice, and admission of service. So in order to be served, you have to acknowledge that you were served or have a sheriff serve you with the papers so the sheriff can verify that you were served, and Grant actually mailed the lawsuit. His wife Julie did not sign that she acknowledged service until August 17th. Therefore, the Supreme Court found that the divorce action was commenced on August 17th, not on July 30th. Now, Grant's attorney kind of looked like a jackass, same as Tim's attorney did. So what did he do? After he filed the lawsuit in the court system in South Dakota, and now it's in the mail, he quickly had Grant, same like Mitch Johnson tried to have Timothy Evans do, change his driver's license over. And what the Supreme Court found is that according to South Dakota law 15-6-4, And 15-2-30, the action is commenced when the summons is served, which we've already established with the time. Now, continuing on in paragraph 12, the legislature, and I'm quoting directly from the Supreme Court's opinion here, the residence must not be a residence simply for the purpose of procuring a divorce. Grant got a house. Remember, Timothy John Evans did not obtain a house. He claimed Rachel, his wife's address, as his home address. Now, Grant was living by himself in South Dakota. His wife, Julie, was living in another state. Grant obtained a South Dakota driver's license on August 3rd, and then he also registered to vote on August 6th. He moved to South Dakota and obtained a home around June 29th, and then he began to receive his mail at this house on July 1st. He opened up a South Dakota bank account, and he obtained employment. So he had all of these physical manifestations of actually changing his residency, including registering a vehicle. They therefore found that Grant was a resident by the time of August 17th, and the courts of South Dakota had jurisdiction. So what exactly establishes residency in South Dakota besides this Rush versus Rush case, which the Supreme Court had decided? Well, South Dakota clearly states factors which terminate a South Dakota residency in SDCL 41-1-1.2. A person is deemed to have terminated a South Dakota residency if the person applies for, purchases, or accepts a resident hunting, fishing, or trapping license issued by another state, they register to vote in another state, or they accept a driver's license issued by another state. So let's go back to Timothy John Evans. He was registered to vote in Montana. He was actively hunting in Montana, and all his vehicles were registered in Montana. He had a house in Montana, and he had a driver's license in Montana on January 23rd, 2018, the day that he filed for divorce. South Dakota further defines establishing residency under the following codified laws. There's the concept of living there. So it can't just be a house that you, like a vacation house. It actually has to be your legal residence. You have to be registered to vote 15 days prior to the election in order to vote. In order to register to vote, you have to prove that you're a South Dakota resident. And the South Dakota Constitution provides that a person does not lose the right to vote in one jurisdiction until that right is established in another. So if Timothy John Evans was registered to vote in Montana and voting in Montana, he cannot be voting in South Dakota at the same time. South Dakota has the hunting and fishing licenses. You cannot obtain a resident South Dakota hunting or fishing license if you're actively a resident in another state. And finally, SDCL 41-1-1.1 provides a very detailed list of categories defining persons who qualify as state residents. So in other words, the South Dakota legislature has taken great steps to define exactly how and when a person is considered a resident. Likewise, Montana Code Annotated. So I'd like to interrupt here and say that each state has a different way in how they refer to their state laws. It happens to be South Dakota Codified Law or Montana Code Annotated. It's the exact same meaning. It just says how they refer to their statutes and how they're legally cited. So anyways, when you write them out, Montana Code Annotated defines a resident. Montana Code Annotated 87-2-102, which is specific to the Montana Fish, Wildlife, and Parks, has all of these different criteria for obtaining a resident hunting, fishing, or trapping license. The Fish, Wildlife, and Park also has set higher application fees for non-resident hunters, And you also limit the number of non-resident hunting and fishing licenses issued each year, whereas residents can get as, like there's no limit. A resident can go purchase a license. An out-of-stater needs to be drawn, and there's limited numbers. Montana Code Annotated 87-2-106, paragraph 1, enacts criminal penalties for falsifying residency information. In order to apply for a hunting or fishing license, the applicant must state the street address of permanent residence, mailing address, state the length of time that they've been a resident of the state of Montana, have a valid Montana driver's license, and billing address in Montana for the payment. Montana Code Annotated further defines residence as a person may not swear under testimony of oath or with penalty of perjury to make any false statement or application for a license. A person who is not a resident may not make a false statement to obtain a resident license. This is how you get convicted of criminal charges. And then it specifies the penalties for falsifying your residency information in order to obtain a residency license. It also states that you may not vote at elections unless you're a resident of Montana. Timothy represented himself to be a resident of Montana during 2015 to 2017 when he voted in Montana elections. So this is not a new issue. The Montana Supreme Court had this exact same problem happen with Greenwood. In 2020, they decided a case. It involved this man, Greenwood, who actually lived in Texas, but he had a Montana driver's license, Montana residency, which was like a hunting cabin, and he was hunting big game like elk in Montana, alleging he's a Montana resident, but he failed to pay Montana taxes. Now, Montana has state income tax. You have to pay into it, just like federal income tax at the end of every year on all of your earnings. What the Montana Supreme Court found is that when this Mr. Greenwood was claiming to be a Texas resident for the purpose of not paying Montana taxes on his income, yet claiming to be a Montana resident in order to obtain hunting privileges, and he had a Montana driver's license, had a registered vehicle in Montana, and a home in Montana, the Supreme Court found that more weight is given to the person's acts than to his declarations. And when they are in conflict with each other, the acts are what sets the precedence. They also said that his actions during the years in question spoke volumes. So, all in all, they considered Greenwood's arguments and evidence that he was a Texas resident for the purpose of not paying income tax, but he was a Montana resident for the purpose of big game hunting. And they found that he had a pattern of claiming a certain residency status only when it was favorable to him. Therefore, they said that he was indeed a Montana resident based on his actions, and he had to pay all these back taxes. Interesting, because we're going to bring up in further recordings and episodes how Timothy John Evans did the exact same thing. He refused to pay into Montana income tax, and yet he claimed Montana residency for hunting privileges. So what's the national case law say about this? It says that jurisdiction for the purpose of obtaining a divorce is conferred upon the court when, at the time the action is commenced, the plaintiff, who is the person filing, is a absolutely, beyond a shadow of a doubt, resident of the state. And they have been overturning divorces across the United States from day one when they failed to meet this jurisdiction issue. What South Dakota say on this fact? Well, in 2022, this was a criminal case between LaCroix versus Warden Fluke. Because subject matter jurisdiction cannot be conferred by agreement, consent, or waiver, or acquired, what this means is that every single person, nobody can overturn subject matter jurisdiction. It was clearly established by the legislature. You cannot waive it. You cannot agree that you want to be under their rule. It is 100% without a shadow of a doubt voided. Any judgment issued by a court without jurisdiction is wholly void and without any force of effect whatsoever. That's a criminal case decided by the South Dakota Supreme Court in 2022. Now let's look at a civil case, Goyne versus Hodeschelt in 2020. The same Supreme Court said that they have held that subject matter jurisdiction cannot be obtained through waiver, meaning both parties agree that they're going to deny this requirement by the South Dakota legislature, and therefore they're going to overturn it. The same Supreme Court also said that a question of jurisdiction can be raised at any time. A judgment rendered without jurisdiction is void and without any force or effect whatsoever, and without a valid statute providing so, a circuit court has no jurisdiction. So stay tuned. In the future episodes, remember I told you that in episode 4 this got really juicy. We're going to answer some questions. Who is Timothy John Evans? Why was Judge Connolly so eager to preside over this case? What's ultimately at stake? In DIV 18-41, that a judge would extend his neck and go against the legislature. So black and white. What's at stake? Was he bribed? How much money did he make? When did the evidence of Timothy's mistress come out? What else was involved in this divorce case? Where did Timothy get prosecuted on criminal charges? What happened previously in Montana where Timothy was so scared to file a divorce action in the state of Montana? And then finally, how did the Supreme Court respond to all of this corruption? What do you think Justice Gilbertson and Justice Johnson did? Spoiler alert, they're in on the bribery and dysfunction. So again, the purpose of this presentation is calling the people of South Dakota to hold Governor Noem accountable to her oath. We extensively covered this in episode 1, where Kristi Noem claims that through the South Dakota Constitution, Article 4, Section 3, that she will be responsible for the faithful execution of the law, enforce compliance, restrain violation of any constitutional or legislative power or agency of the state and its civil divisions. So this includes her Supreme Court justices as well as Pennington County Circuit Court, where these violations run so rampant. And stay tuned, because in the upcoming presentations, remember, I'm going to verify every single fact that I say, and we're going to prove how Governor Noem is not fit to run the state of South Dakota or even to be Vice President of America when she intentionally turns her back on all of these violations. We're going to prove how the people of South Dakota established the law. Judges have no authority except to uphold the established law. I just did that in episode 2 and episode 3 now. And we're going to continue exploring what due process of law is and how it's violated every single day by the 7th Circuit Court and the South Dakota Supreme Court in the state of South Dakota. And I'm going to continue proving how the 7th Circuit Court only grants justice to the white privileged male who bribes the judicial system, and how the government is coming in and stealing businesses, destroying families, and imprisoning innocent people. I'm also going to go into detail on how the state's attorney office is involved, the law enforcement, certain officers are involved. Now, I have highest respect for the Pennington County law enforcement. They're not all corrupt, but there are specific people that are corrupt, and I will go into exact detail on who they are. Remember that this is a privately funded public exposure of the perverted judicial system in Pennington County, and all donations are welcomed for this public exposure. Please do donate anonymously, though. Stay tuned for episode 4.